We had a 10-day meeting, Your Honor, and my client was living with a neighbor after this flood, and then May 8th, the county came in and put a tag up and locked everybody out.
Okay, so let's do this. You need to pay 1,500 by the 30th. I want that paid before noon on that date, okay?
Okay.
Then I'm going to adjourn this to May 30th, 2025 at 3 p.m. That's an in-person hearing. And then we'll see where we go from there, okay?
Starting with Ms. Shepard, a tenant left homeless after a faulty sprinkler flooded her apartment, now fighting to recover her belongings at least.
How's the case of Avalon Housing versus Yolanda Shepard?
Morning, Your Honor. Jillian Engen for plaintiff.
Good morning, Your Honor. Andrew Campbell, P64391, on behalf of Yolanda Shepard. Last night, Your Honor, I filed several pleadings, Judge. The matter is a little bit complicated, and I'm not sure if you would, if opposing counsel will be better to describe what's going on.
Your Honor, it's my understanding that there was a flood in the unit. And so I think that the parties are attempting to resolve this. However, my client needs to go in and complete repairs. And so we're trying to coordinate retrieval of Ms. Shepard's belongings. We're trying to figure out kind of how to move forward. But my client does need to get into the unit and ensure that, there's not going to be entry by Ms. Shepard. And so we filed the ex parte motion with that intent that the court would give authority to plaintiff to remove and secure defendant's personal property and then dispose of anything that was damaged that's in the leased premises.
And
May I add? I'm sorry.
Go ahead.
Yeah, if I may, Your Honor, just to add to that a little bit. We had a 10-day meeting, Your Honor, and my client was living with a neighbor after this flood, and then May 8th, the county came in and put a tag up and locked everybody out. May 9th, opposing counsel emailed me because the day before I had emailed them asking about the case. And they sent me the pleadings and also the notice to quit and the health hazard. Now, those were served, Your Honor, just so you know, on the same date that these pleadings were filed. So I filed yesterday a motion to dismiss for lack of jurisdiction and a response to the defendant's motion, as well as an answer and affirmative defenses. We are trying to work with them.
Well,
we're not.
Let's deal with the jurisdictional issue. What is your jurisdictional issue?
Well, Your Honor, it's my understanding that MCL 600.5714 states a person entitled to possession of premises may, meaning it's permissible to recover possession by summary proceedings after a person holds over premises. So to hold over, you have to be served the notice to quit. If you send a 30-day notice, you got to send it, give them 30 days to comply, and then file your summons and complaint. Or in this case, they did both a 30-day TOT notice and a health hazard notice, but they sent the health hazard notice on the date of filing. And respectfully, I think that that's violating the law because you're supposed to give them 7 days to get in. And frankly, that's hard to do so when the county has locked you out. And so the court lacks jurisdiction because the requisite requirements by the statute were not met prior to filing. And I listed all the law in my brief, Your Honor, in my motion. Ypsilanti Housing Commission versus O'Day, plaintiff's termination notice is improper and void. And also Park Forest versus Smith, a proper termination notice is necessary for the court to have jurisdiction. And while the notice was valid in respects to perhaps the content, although we disagree with the assertions, it was not timely. It was not filed in a timely manner. And so my client never had a chance to kind of abide by the demands of the notice. And additionally, I filed a motion for discovery if the court was not going to grant it. because the fire report, I'm quoting from page 1, incident type sprinkler activation, no fire, unintentional. It also states, quote, there was no fire or smoke in the building, end quote. So my client, she wasn't responsible. Apparently this sprinkler, I haven't been in the apartment because we're locked out, but it's cathedral ceilings. It's way up. My client tells me she can't even reach it with a ladder. So the sprinkler just went off and caused all this water to be ejected. She's been, and Avalon has been assisting. They did offer a hotel, but she couldn't get transportation to the kids for school, so she stayed with a neighbor. Now they're offering a hotel again, which we're grateful for, and we want to take advantage of. But my client is poor and doesn't have a lot of money and needs to be able to get a U-Haul and a storage unit. So she went to Faith in Action and should be hearing from them today.
Why are we going through all of this? It's the unit is untenable, correct?
Well, that's the conclusions they state. They're stating it's untenable, and I don't know I don't know for sure. I don't see any insurance adjusters reports. I don't see anything. There was an inch of water.
I guess I'm not even clear why we're going through this. Under paragraph 31 of the lease, the landlord wants to enter the premises to secure the premises.
Yes, but there's a couple problems with the order, and the order that they proposed, Your Honor. Let me get specific, and because I've been through this before. I've been down here for 3 months, and I've seen this before. And it says it's further ordered that plaintiff may remove and secure defendant's personal property from the leased premises. And here's the problem language: dispose of any rubbish, trash, waste, and other water damage and or flood damaged items contained in the leased premises. That's a problem because any maintenance person.
Then why don't you just ask that they can just look at that? Your client can look at it. I mean,
that's what I did in my motion that I filed.
Don't interrupt me. Why are we going through all of this? They need to get into the premises. They tag the unit. They need to get into premises. Otherwise, more damage is going to occur, both to your client's property as well as to the tenant, to the unit. Doesn't make any sense to me why we're going through all of this.
I'm sorry.
If the issue becomes the destruction or the disposal of property, then certainly I think council should be able to arrange that as the property is being removed, your client can be there to try to salvage what property is salvageable.
May I speak, Your Honor?
Go ahead.
I apologize for interrupting the court. Judge, there's a lot of issues in this case. If you look at my motion, my response, the problem we have is we want that, Your Honor. We asked at the 10-day meeting for opposing counsel to contact the county and get the county's schedule when they can come out and open the door for my client, and my client can then go in. Nobody can enter without the county's permission, Judge. Okay? That's what we want. But what we don't want is we don't want some maintenance person looking at the goods and saying, oh, that's water damage.
Why don't you and council get together, contact the county, and arrange a time to go down?
I agree.
What is so hard? What is so hard about that?
There's nothing hard, Judge. It's not on me to do that, Judge. It's a plaintiff's case. And we had a meeting. And
counsel, your client has property that she may want to salvage. It would seem to me that it would be in your interest to contact plaintiff's counsel, get with the county, figure out a time that the parties can go in there. It's in all parties' interest to do that. Your client, the landlord, everybody's interest to get into the unit, get out those items that your client that are salvageable, allow the landlord to go in, repair what's there so that further damage doesn't occur.
I agree. And that's why we had a 10-day meeting.
All right, here's what we're going to do. I'm adjourning this to next week. Between now and next week, I'm going to order that council get together with the county, arrange a time to go into the premises for inspection of the premises and removal of those items.
Thank you, Your Honor. And so at this time, I just want to clarify, Your Honor, you're not entering the ex parte order as drafted.
I'm not going to enter that order. I'm going to enter the order directing the parties to get with the county, enter to gain entry to the premises, that defendant is to remove those items that she wishes removed.
Thank you.
And then plaintiff is also able to secure the premises and stop any further waste on the premises.
Thank you, Your Honor. Two things briefly, Your Honor. We would like to reserve escrow or preserve escrow from today's date. Also, the case was filed under 657-14 1C 1i after termination of the lease pursuant to a power to terminate provided in the lease or implied by law. Obviously, we can talk about that later. I just want to have that on the record.
Well, that's why I don't see the jurisdictional issue, because I think it's properly filed pursuant to the provision in the lease, but we can argue that at another point. But I'm ordering that, and I'll set this for May 30th, 2025 at 3 p.m. That's in.
Thank you, Your Honor. Would you like us to submit an order to the court in accordance with?
Please.
In person didn't mean I was supposed to be here. I wasn't even supposed to be here.
And now we have this man who dodged back rent for months while still occupying the property, now demanding 6 more months to move out.
He feels for one reason or another that there was an agreement that if he moved out, which he still hasn't moved out, that he didn't owe any back rent. Did I accurately?
Correct.
Those
Yeah,
are,
we had a verbal agreement that if I was to move out, that I would no longer be paying the rent. I told him I couldn't pay the rent and move out. And I thought we had come to a mutual agreement that it would be best for both parties if I just moved everything out.
and it's my client's position that no agreement was made. And even if one was, the client still hasn't moved out and still wants another 6 months to move out, Your Honor.
Sir, you're not disputing that the rent's owed. Right?
Well, I am, because I had an agreement with the landlord to, if I moved out, in lieu of paying the back rent.
Which he hasn't moved out, even if there was an agreement, Your Honor.
But I'm in the process of moving out. It's,
But
Really, guys, I hear you. You guys can keep repeating it, but I can.
I'm sorry, Your Honor.
From one moment to the next. I get it. So, I mean, there are two parts, so that you understand this, sir. There are two parts of this case. One is the possession issue, and then the monetary issue. In terms of the possession issue, I don't see that there's an issue for me to try, because the condition of you staying is, first of all, to pay rent. Even if, I'm not saying that I'd make a finding that there is, even if there is this other agreement that you move and you don't owe the rent, the only bearing that has on the possession issue is you were supposed to move, right? So I can bifurcate the hearing so that we deal with just the possession issue and then set it for a further hearing as to the money claim. But if I do that, then the question is when are you going to move? Because I think they'd be entitled to a judgment for possession. And the reality is that if I do that, finding no tribal issue on the issue of possession, it's going to be 10 days. I can tell you that even using my discretion, I wouldn't give you 6 months to move. So if we just deal with that part of it, when can you be out?
I mean, I said realistically 6 months because there's so much stuff. I understand that that's not agreeable with them. But I've tried to work with them. I even offered another solution to conduct a liquidation auction. But I said, even that's going to take, probably 2 months realistically, and everything still won't sell. So I did make a promise that I would clear the property out in lieu of not paying rent, that I would make sure that it was, left empty. And that's why I came up with the 6 months, because I know that's still going to take time, even after I liquidate a vast majority of the stuff. It's still going to take time to remove the junk, and I'm willing to pay for the removal of all the trash that's in there and leave it empty. But I don't think that's agreeable.
They've said it's not agreeable.
The other problem I'm having is I just found out recently, a few minutes ago, that the person I've been dealing with apparently is no longer the owner of the property. So the person that I've been dealing with, the person that I had a verbal agreement with, I guess is no longer, making the calls, and I was not aware of that, which I guess explains why I haven't heard back from the person that I had made this deal with, because I just found that out a few minutes ago.
Well, Your Honor, speaking to that aspect only, the owner's still the owner. The son has been managing the property for the last year or so. So I don't know I think that's what you're referring to,
I
correct?
guess I just meant I wasn't aware that, the person that I was talking to isn't actually running the operation anymore, so, when I was told, I won't charge you any rent if you can move everything out, you know, and at the time I talked to him last, I didn't give him
Yeah,
a time.
Let's, again, the problem with that is, if I assume that's true, you haven't moved. I mean, if you haven't moved, that means you still owe the rent, right? Which means they'd be entitled to a judgment and you'd still owe the money.
But the agreement that I had was that I wouldn't be paying anymore if I moved out.
But you haven't moved out.
Correct. I'm in the process of moving out.
Well, according to his own words, Your Honor, that's a 6 months ordeal. So, I mean, I could say I'm moving out of my house by taking a dish at a time.
Well, this isn't a one bedroom apartment. This is a 10,000 square foot warehouse that's packed to the rafters with stuff. So it's not, you know, it took several years.
I get back to my same question. For you, how much time are you looking? 6 months is not gonna happen.
Okay.
So
I-
here, just let me finish this. The statutory period would be 10 days.
Right.
I get the circumstance that you're in, so maybe that's not realistic that it's the 10 days.
Right.
But I can tell you that even if I use the furthest reaches of my discretion to give additional time, it's not gonna be near 6 months.
Okay.
And so if you guys can't decide, I'm gonna pick a date on the possession issue, and then I set it for trial on the monetary issue. But you guys are gonna have to decide. It's gonna have to be something realistic, sir. I mean, they're entitled to the possession of their property by even what your agreement was, they're entitled to possession.
I mean, I can guarantee I can't move everything out in 10 days. It's not,
How much, what would be the fastest?
I mean, 4 months, is that agreeable?
No, that still puts us in the
I
same
mean-
position.
It's, like I said, I've probably moved half of it out within the past, 3 months. It's gonna take, I would say, at least 4 months, realistically.
I mean, no.
We'll let Your Honor make that decision.
I've listened to everybody. As to the issue of possession, I'm gonna find that there's no tribal issue as to the issue of possession only. I'm gonna issue an order of eviction on or after June 30th.
After what, June 30th, Your Honor?
Yes, June 30th.
Thank you very much.
I will also on the damages and money issues on the case, I'll set a trial on that matter for July 15th, 2025 at 9 a.m.
Thank you. And I will prepare the order on the possession. I'll submit it to the court. I'll submit a copy.
Will I be getting a copy? Because that's the other thing. I haven't received any court summons or anything.
Well, we have a proof of service in the file, Your Honor. We'll use-
What do you mean you haven't received any summons?
The only summons that I received was the one that was taped to the door, and
Well, that's service.
I was under the impression that I was also supposed to be mailed something as well. The one that was taped to the door had the address in Saline, which is why I wasn't here at noon, because I went to the courthouse in Saline and they said, "Oh, you're at the wrong place." And then I called the number that was on the summons, and the number was for Wayne County Courthouse. So my summons that I received on the door was riddled.
So what do you want me to do with that? You're here. I've heard your case.
I'm just saying, am I going to receive?
Yes,
mailing?
I'll tell you what, here's what we'll do. You'll get a judgment. Prepare a judgment. I'll sign it and I'll give you a copy. Thank you.
The judgment up at the counter.
Yes, get a judgment out at the counter, sign it, and then get it all prepared and then I'll do that.
Thank you, Your Honor.
Arbor Woods versus Masheri Taylor.
Good afternoon, Your Honor. Sydney Final on P86316 for the plaintiff.
Good afternoon, Sydney. Your name?
Mashari Taylor.
All right. And where are we on this case?
This time, it's Ms. Lucas, owing thousands in back rent but spent the money on her car instead, now begging for more time to pay.
Thank you, Your Honor.
Court calls the case of Arbor Woods versus Dominique Lucas.
Sydney Fontanella for the plaintiff, Your Honor.
Hello.
How you doing?
Okay, what's your name?
Dominique Lucas.
All right. Okay, what do we have her balance?
Your Honor, I'm showing that her current rent due is $3,237.16. Court costs of $186 for a total of $3,423.16 currently due.
And what do you have to say? Did you didn't make the payments you said you were gonna make?
No, I had some issues come up, so I had to use the money for my car.
What is your monthly rent?
$14.49.
How are you gonna try to get this paid?
I have 700 today, and I can make the rest of the, what was that, be 2736, I believe, by,
Okay, so you're saying you can get this total amount paid by June 4th?
yes.
Okay, so here's what I'm gonna do, young lady. I'm gonna find no tribal issue after hearing. I'm gonna grant a judgment for possession for the amount of the $3,423.16. And writ issue, I'll make it June 6, 2025. Over plaintiff's objection, maybe. All right, so you got to the 6th to get all that.
Okay.
I would get, if you got the 700 day, get that into them, so you get that balance now.
Okay.
This judgment doesn't include anything having to do with your June rent.
Okay.
It's just the back portion.
Okay.
Okay?
I got a question for you.
Okay.
I
have an answer for you. No, I don't know. Maybe I don't.
I seen you in February. When I seen you in February, did you include March's rent into February?
Whoa. You're okay. I would love to be able to answer your question, but I've probably seen, I don't know how
Okay.
many cases.
Yeah. Okay.
So what was the date in February? You know?
I don't remember the date in February, but I know I had to have everything paid by March 10th, which I did. I don't remember the date in February.
Just a second.
Was it February 28th?
Oh, give me just a second. Let me see what I can find in our system.
She was here in January.
Was it January?
Okay, I don't see a judgment in February. I see a judgment in January.
Okay.
Yeah, it looks like there was a judgment entered on January 24th.
Oh, sure.
I'm her mother.
Okay, come on up with your daughter. What are you, because you're gonna sit up there and yell at me from the back. What's your name?
Luella. Hi. I think the questions that she's asking when she was in here in January, from her understandings that the February or whatever following month was included within that balance.
Okay.
And I think this is where she's getting off a track.
Gotcha. So I can't say for sure, but I can tell you that generally, if the judgment was January 24th, February rent was not included in that.
Okay.
Okay, that would only included what was due then.
Okay.
Okay,
Okay.
all right.
That's good with me.
See, it's good that you have your mom, because I understood what she said. I didn't know what she said. No, I'm kidding.
Thank you.
Now here's Ms. Brown, who claims she already paid $2,400 only to learn in court the payment hadn't cleared as she faced eviction. Crazy, right?
Chat, and so you can make that request directly there, okay?
All right, thank you.
Thank you. Gulfside Lakes versus Sarah Brown and Jalen Brown.
Jillian Ingram for plaintiff.
Good morning, Your Honor. I'm here.
Good morning. Your name?
Miss Sarah Brown.
You're Sarah Brown. Okay.
Yes, sir.
You got it? Okay. And what is plaintiff's claim?
Your Honor, I have a balance including court costs of $3,473.47.
All right. And ma'am, how are you intending on getting that paid?
That's not the cost that I have. I don't know if they received the $2,400 that I paid last night.
We wouldn't.
Okay.
know.
Okay.
You would not have.
That would
So you
make
paid
sense.
$2,400 last night?
Yes.
Okay. I'm gonna indicate that was the 22nd. You paid that.
Yeah.
And then,
and
so that leaves you about 1,000 and some change. So when were you gonna get the balance paid?
I could pay the balance by either in the evening on the 30th or early morning on the 31st.
Okay. So it looks like there may need to be a COD if you can't get it paid by noon on the 30th is what you're telling me.
I can try. I don't want to make that promise because my money hit like different times, if that makes sense. I'm sorry.
No, that makes sense. I got you.
Because sometimes it hit earlier in the day, then it'd be in the evening. It's crazy times. I'm sorry.
Okay, all right. So here's what I'll do. I'll
Okay.
let them try to get their accounting and get your ledger all caught up. I'll adjourn this to May 30th, 2025, 3 p.m. That's an in-person hearing. And then we'll try to figure out how we're gonna work it out if it's not paid by then.
Okay, can
All
I
right.
get that? May I get that balance again she has so I can minus the 2,400 from it so I'll know what I owe if that's okay?
Yep, yes, and I have $3,473.47. You can
Okay.
also contact Melissa. She'll
Okay,
give you a, your-
okay, yeah, and I'll definitely try to have that paid before 3 o'clock on the 30th. Thank you, Your Honor.
All right, all right. Thank you.
Finally, we have Mr. Worth, a tenant who fell behind on rent, now scrambling to avoid eviction with a last-minute payment plan.
Thank you. You have a great weekend.
You too, bye-bye.
Court calls the case of Glencoe Hills versus Daniel Worth.
Hello.
Hello, Mr. Worth. Do you have a camera?
Yes.
Okay, I'll need you to turn that on, but while you're doing that, oh, you got it on. Okay, what is plaintiff's claim in this case?
Your Honor, I have a balance including court costs of $3,067.63.
All right, Mr. Worth, how are you intending on getting that paid?
I have a payment plan that covers next month rent, but it wouldn't be, my balance would be at zero by next month of the 30th.
Okay, have you talked that over with your landlord?
Yeah.
Your Honor, I don't know that plaintiff is willing, I don't know if we're willing to do, I don't know if plaintiff is willing to do a COD on this one. I can ask my client.
All right, so here's what I'll do, Mr. Worth. Is there anything you can pay between now and next week?
I could do, what does next week fall on?
The 30th of May.
I could pay 1,500.
1,500 by that day?
Yeah.
Okay, so let's do this. You need to pay 1,500 by the 30th. I want that paid before noon on that date, okay? Then I'm going to adjourn this to May 30th, 2025 at 3 p.m. That's an in-person hearing. And then we'll see where we go from there, okay?
Could you do June 2nd for the first payment?
I cannot,
okay.
because if you're not gonna, if you can make the payment, you need to make the payment, sir.
Okay, I'll make the payment. I could make it by June 2nd with that 1,500.
All right. Well, I'll put that in the file, but I'll still need you here then on the 30th
Okay,
at 3 p.m.
Okay, thank you.
Glencoe Hills versus Daniel Reynolds.
Jillian Engen for plaintiff.